Hello, my name is Michael Katz. I've been practicing franchise law since 1979, and I represent franchisors and franchisees from around the world. I'm also contributing editor to the Franchise Bible, which is published by Entrepreneur Press. This lesson will explain the difference between a franchise and a license. We'll compare the two relationships, and we'll learn that while every franchise is a license, not all licenses are franchises. Here's a definition of a franchise that most often is recognized. It's a contract between two parties where one party, the franchisor, authorizes the other party to use the franchisor's trademarks, trade names, logos, and intellectual property under the franchisor's significant direction and control for a fee. Let's compare that definition to the license arrangement. I think you'll be surprised to know that a license is a contract between two or more parties where one party, licensor, authorizes the other party, the licensee, to use licensor's trademarks, trade names, intellectual property, and logos under licensor's direction and control for a fee. Yikes, they're virtually the same. The subtle and very subjective difference is the amount of direction and control the owner of the marks, whether he or she is called a franchisor or licensor, exerts over the other party's use of the marks and operation of his or her business. Why is this important? The subtle differences become very important when one understands that the franchise relationship is governed by the Federal Trade Commission and is subject to some 19 different state laws. On the other hand, a license relationship is viewed as any other commercial contract and is not subject to federal regulation or to any other state regulations for that matter, beyond the laws that control any other contract. Then how's a person to know what a true relationship is? There's no bright line that separates the relationship, but here are some secret lawyer tips that may help you figure out what the relationship is. First, when in doubt, check it out. Hire a lawyer that is experienced in franchise law. Franchise law is very sophisticated and complex, and only attorneys that have experience in the area are equipped to help you make what may be the single most important business decision you'll make. Second, look at the title. If it says it's a franchise, then it will be treated as a franchise, even if the franchisor did not intend it to be in fact a franchise. Third, understand how much control the mark owner wants to exert on you. The owner of the mark, under either relationship, has the right and obligation to ensure that the person using it is doing so in a way that will enhance the goodwill of the trademark. If the owner of the mark merely states that he or she has the right to monitor your use and has the right to require you to make changes to your business only if the marks are misused, then it's most likely a license. If, on the other hand, the owner of the marks has the right to ensure the goodwill is protected, but also has the right to dictate how the business is to look, what hours you're to operate, what goods or services can be offered at the business, and then provides training on such topics as marketing, business management, and the like, then the relationship is most likely a franchise. Though much less important, most franchise agreements run in the dozens of pages. Indeed, it's usual for the franchise agreement to be between 30 and 60 pages long. More often, a mere license is only about 10 to 15 pages. Fifth, look at the ongoing fees. Though somewhat tricky, more often, a licensor charges only an initial licensing fee and ongoing licensing fees in the forms of monthly or yearly royalties. In a franchise, however, not only is an initial fee paid, but an ongoing royalty fee is charged, along with ongoing marketing fees and fees for other goods and services. Finally, consider your own business sophistication. If you have a business that's already up and operating, have revenue outside of what is expected to be generated by the license arrangement, and you have your own marketing plan, then the arrangement will most likely be treated as a license. If, on the other hand, you're being taught how to operate a business, are being told what to sell, are being required to attend training, and are earning most of your income from this business, then it's most likely a franchise. And did I mention you should hire a franchise attorney? Seriously, This business arrangement may well be one of the longest lasting and most financially impactful relationships you'll have in your life. It's worth the money to consult an expert. That's it. Remember, the franchise or license relationship will have a long-lasting effect on the operation of your business. At a minimum, you'll be using someone else's intellectual property to increase your revenue and the goodwill created for your business. As a responsible owner, it's in your best interest to understand the nature of your contractual relationships. I hope you've enjoyed learning about the difference between franchises and a license. I'm Michael Katz, and thank you for watching.